Hi, everyone. My name is Nathaniel Player. Thank you for joining us for our presentation. This is the presentation on evictions. We titled it, These Things Come in Threes, and we'll explain why as we go through it. I'm excited to be joined by two illustrious colleagues. I've got Marcus Deegan, who's going to join us, and Jeff Daybell. Marcus Deegan is an attorney with Utah Legal Services. He focuses primarily on eviction defense as well as debt collection matters. Marcus has provided direct assistance to hundreds of low-income tenants and debtors in Utah, as well as provided training and supervision for dozens of volunteer attorneys working toward the same ends. Marcus first gained his public interest after working in the Peace Corps in Nicaragua from 2011 to 2013. He's remained in that field throughout his 2017 graduation from Colorado University Law. He still continues to do public interest work. Along with serving on the board for People's Legal Aid, Marcus enjoys experiencing the natural beauty around his new home of Utah. We're also joined by Jeff Daybell. Jeff Daybell is the executive director for People's Legal Aid. It's a nonprofit that services people facing eviction. They provide legal defense. They also help with debt collection issues. Jeff is also the staff attorney for the Access to Justice Office at the Utah State Bar and has a small private practice. Jeff is passionate about eviction defense and has represented hundreds of individuals. He attended the University of Utah's S.J. Quinney College of Law. Before that, he served on active duty in the military as a military police officer. And my name is Nathaniel Player. I'm the director of the Utah State Court's Self-Help Center. The Self-Help Center is a free resource that provides free legal help and information to anyone facing any state law issue in Utah. I'm excited to be on the panel with these folks. They're really passionate. They really care about this issue. Again, the name of our topic today is evictions. These things come in threes. And there are three things that come in threes. One is 3-day notices. We're going to talk about that. The other is 3-day summonses. We'll talk about that. And then we're going to talk about 3 times the rent and what that means. So it's a lot of threes in evictions, a lot to keep track of. We'll try and help you understand it and make sense of it. So what we're going to cover today is a little bit about the legal process, what evictions look like, what people can expect, and then we'll talk about legal defenses and consequences of eviction, talk about resources available, what's out there to help people, and then we'll save time at the end for some questions. This is being recorded, so Marcus and Jeff will be available right now to answer questions, and then at the end, I'll be available in live when we're actually taking questions from the audience. So thanks again, Marcus and Jeff, for joining us. I appreciate your willingness to be here. It's throwing me off because Jeff's link says Nathaniel Player, but he's actually Jeff Daybell down there. Can you wave, Jeff, just so they know who you are?
I've wanted to be you for so long. I'm glad it's finally.
It's definitely throwing me off. I'm like, that's not me down there. Let's get started. Marcus, can you talk to us a little bit about the eviction process and how that works?
Absolutely, Nathaniel. Thank you. So yeah, to start off with, we wanted to give a little context for what the eviction process looks like. And the reason why this is important is because ultimately, while tenants do not have perhaps extensive rights in the state of Utah, one right that all tenants do have is a right that if they're going to be evicted, physically ejected from their domicile, that there has to be some sort of a judicial process, or sometimes this will be referred to just in the common parlance as a civil proceeding. This means that the landlord must actually take the predicate steps in order to be able to file a lawsuit, then actually file a lawsuit and bring that lawsuit to term such that a judge signs an eviction order. This eviction order is typically titled as an order of restitution. Whenever one sees the phrase order of restitution, that simply means the eviction order, the order that a landlord can hand to a constable and physically throw somebody out. But absent a lawsuit and such an order, an eviction may not take place. So to start off with, in order to even try to begin an eviction lawsuit, the first thing a landlord has to do is give the tenant an eviction notice. Nathaniel, do we already have, well, should we jump straight into a flow chart or any other
Yeah,
demonstratives we have?
Why don't I show the flow chart, and I'll just share my screen and show people how I'm getting to where I'm going. Give me one moment. Okay, so here is Google Chrome, and I went to utcourts.gov. It's the court's homepage. And from here, I'm going to click on all self-help resources. And down here, there's lots of different resources on lots of different things. Today, we're talking about eviction. So I'll scroll down here to where it says housing.
Nathaniel, actually, your screen is showing the outline rather than the
Oh, it's
self-help
showing the
screen.
wrong screen. Let me stop that for a minute and get you the right screen. Give me 1 minute. Oh, I'll just do this. Okay, if I go to, now can you see the right screen?
Correct.
Thank you. So if I go to utcourts.gov, I click all self-help resources. I scroll down here to where it says housing, and there's this flow chart. I'll click on this PDF. And now I'll stop talking and let you carry the show, Marcus.
No, thank you for jumping in with that, Nathaniel, and particularly for bringing up how to pull up these self-help resources. Actually, right now, we're going to have a chance to plug our services towards the end of this, but I really want to make a point now to plug the incredible value of what is done by the Self-Help Center and what the self-help resources that are posted on utcourts.gov. I have seen several other states' similar resources on their own state court websites, and they are woefully deficient compared to what Mr. Player and the Self-Help Center put together. So kudos to that. So now with that in mind, and do check out those self-help resources in case one of us blitzes past this topic or some question you might have, because we are prone to talking fast and going by quickly questions that people might want to know more information about. So as I was discussing, no eviction can happen without a lawsuit. But before a lawsuit can take place, the landlord must take an additional step, and that is the service of a notice on the tenant. So as Mr. Player is highlighting right there, yes, the first step is service of a notice to the tenant. Now, if you will have a lease agreement that specifies a term of time, so I signed, today is September 1st, if I signed a lease saying that I was going to be there from September 1st of 2020 until August 31st of 2021, then during that time, the only kind of eviction notice that my landlord could give me would be an eviction notice that stated some good cause for evicting me. Now, I bring up this point so that we can distinguish between if I have a lease that is no longer on a current term, or if I never had a written lease to begin with, or if my written lease was only ever on a month-to-month basis, then an eviction notice does not have to have any cause stated in it whatsoever. That notice must simply tell me that I must get out by a certain date, and that if I do not, that an eviction lawsuit will ensue. Importantly, that no cause eviction notice must be served on me a certain amount of time before the end of a month. It specifically has to be 15 days. So for example, if I was to be given a 15-day notice to vacate, as these notices are commonly captioned right in big bold letters at the top, 15 days to vacate. If I got a 15-day notice to vacate today, saying that I had to be out on September 15th, that would be bad notice, because the notice has to tell me to leave at the end of a month. If I got a 15-day notice to vacate today, but it told me I didn't actually have to leave until September 30th, that would be valid notice. All other forms of notice generally tend to give a tenant much less time than a no-cause notice. Good notices to evict for cause are typically where we get this whole 3-day number. It's 3 days to pay or vacate, 3 days to comply or vacate. That's usually if there's some sort of rule being broken or alleged to being broken. 3 days to vacate for instance, committing a criminal act on the properties. The law doesn't give any chance to fix things up. In a pay or vacate, If you pay up the money, you don't have to vacate. And a comply or vacate, if you comply, you don't have to vacate. But a 3-day notice to vacate, there's no other opportunity to fix things. That is the landlord signaling, I am not giving you any further chances. You must get out. Now, importantly, the notice has to be properly served on the tenant, but that is a very low bar of service. An eviction notice may simply be taped to a tenant's door or stuck in a normal mailbox. I believe it typically needs to be certified mail, or it can just be handed by the landlord or property manager to the tenant. There's a step where presentation of papers to a tenant has to be done by somebody specifically that comes later on. But as to just the eviction notice itself, there are no formalities needed. It does not need to be a legal document or look like a legal document. It does not need a judge's signature. It does not even have to be typed. A valid eviction notice can be simply handwritten as long as it contains the necessary information about how many days to get out, whether or not there's a cure opportunity, like in a pay or vacate or a comply or vacate, and a date on which the person has to vacate. If a notice does not contain those required formalities, then there might be an eviction defense. Jeff will be talking about that a bit later. But the point is that an eviction notice does not need to be any kind of formal document. The most critical formality that must be observed in an eviction notice, typically speaking, is that it be a piece of paper. A landlord or property manager cannot simply send a text message or an email with the appropriate eviction notice language. The law does require it to be a paper document presented in some fashion to the tenant. So you get the eviction notice. The eviction notice gives a certain amount of time to either do something or get out, or to just get out. If the matter is not cured, or if there's been no opportunity for cure and the tenant still is not left, very importantly, the landlord cannot then just summarily lock the tenant out. Once again, a judicial process must be observed. Some landlords will sometimes threaten that they will evict somebody as soon as the eviction notice has expired. This is a bluff and should be ignored. But after the eviction notice expires, that is when the landlord must file what's in the most common parlance just referred to as court papers, first with the court, and then get a copy of those papers served on the tenant. Now, this is quite crucial, that the initial court papers, this is often referred to in shorthand in the legal industry as the summons and complaint. As you know, working with tenants, you will most likely just hear them referred to as the court papers or the first court papers. It's always very important to distinguish between whether or not somebody is dealing with, if you're working with a low-income tenant, they said they got some papers from their landlord. It's really important to establish very quickly, is this just merely an eviction notice, or are these indeed court papers initiating a lawsuit? Usually simplest shorthand way to be able to distinguish is that the notice is typically just a single piece of paper, or at most 3 to 5 pages. It's extraordinarily rare that an eviction notice would come with sufficient additional documentation that it would be more than 5 pages long. If somebody who you're talking to says they got papers from their landlord about an eviction, and they tell you it's something more on the range of 10 to 20 pages or more long, there may be a significant risk that those are in fact the court papers initiating the lawsuit, and therefore need to be addressed quite emergently. And I'll explain why that is in just a moment. But as stated, the landlord must first both file the court papers with the court and then also get them properly served on the tenant. And this is the stage where proper service is critical. Proper service must be conducted by a third party who does not have any interest in the outcome of the lawsuit. That is to say that a landlord or their property manager cannot be the one to serve the court papers. It is typically done by a sheriff or constable. It does not have to be. It could be any random stranger off the street, as long as it is a person who has no interest in the outcome of the lawsuit whatsoever. If a tenant is claiming they just came home and found the court papers stuck under their door, that would be a potential defense and a cause for further conversation. After the court papers are served, from there, the tenant only has 3 business days within which to file a document with the court in order to prevent a default. A default is effectively the landlord just getting an automatic win. Sometimes defaults can be undone, but they are very difficult, and you should function under the assumption that the 3 business day timeline for filing this responsive document is going to be hewn to strictly by the court. Now, the document that has to be filed with the court within these 3 business days is called an answer. Typically, you'll see in the paperwork a capital A answer is the document that has to be prepared. This is a very simple document. Some tenants are very intimidated filling it out, but it is generally quite simple. And when in doubt, tenants are best to deny the allegations based on the lack of amount of time, or just simply state not enough information about whether or not to admit or deny what is said in the initial court papers. But an answer is exactly what it sounds like. It is just giving an initial response to the court papers, the complaint filed against the tenant by the landlord. And it's the tenant's opportunity to give their statement of why they should not be evicted. After an answer, well, first of all, very critically, an answer is not filed within those 3 business days, a default enters, and then the tenant is going to have a very hard uphill battle getting that default undone. Typically, after a default, then comes a default judgment, in which the judge basically gives the landlord an automatic win as to the question of money being claimed, as well as simultaneously with the default judgment, also an order of restitution. Sometimes these orders of restitution, particularly in a default situation, are immediate orders of restitution, meaning that the landlord can kick out the tenant the same day that the order was signed. More commonly in a default, an eviction order will give a tenant 3 days in which to vacate the property before the landlord could come in, physically eject the people, and change the locks. If an answer is filed on time, then the next step is either party requesting what's called an occupancy hearing, or sometimes this is called an immediate occupancy hearing. It is just as urgent no matter which title you give it. But the main thing to convey to any client you're working with is to tell them, let the landlord be the one to request the court hearing. There's no need for the tenant to request the hearing themselves. The landlord will almost certainly do it. And for that matter, every day that the landlord does not request a occupancy hearing is another day that that tenant has to either prepare to move out, or if they have a good defense, to prepare their defense and gather evidence for mounting that defense. Then from there, once the occupancy hearing is requested, then the judge is required to set the occupancy hearing date. Typically, on the hard letter of the law, the judge must set the occupancy hearing for within 10 days after the answer is filed. Judges jealously guard their right to run their calendars how they see fit, but generally speaking, judges do, if they don't meet that 10-day requirement, keep quite close to it. And in some jurisdictions, all eviction hearings are actually held by the same judge on the same day each week. So it's always good to keep an eye out for a notice of a hearing being sent to any tenant that you might be working with. Also quite critical to know about the filing of the answer, and I should have mentioned this before, I apologize, but under the current rules of civil procedure, when a person who is a defendant on the receiving end of a lawsuit, when they file an answer, they have an opportunity to put in an email address on the first page. You should make sure that the person you're talking to knows, the tenant knows, that they should not put anything in the email blank unless that email address is one that they actually check every day without fail. This is crucial because if an email is put in that email blank on the answer form, the court is going to assume that the court can continue to communicate with that defendant over email. And that may include both things like the date of the occupancy hearing itself, and also for important events that may happen afterwards. From there,
Thanks, Marcus. I'm going to take over the time just a little bit, but I do want to ask one question that I think a lot of people will have, which is, if I'm a social worker or a case manager and I'm trying to help somebody and they're in these early stages, what do you want them, what can they do to help? What advice do you have for them to help the client? Because I think everybody's mutual goal is to keep somebody off the street, keep them housed, or help them slow down the process if possible.
That's a great question. Well, the first advice I would give, perhaps in a bit of a self-interested fashion, is call Utah Legal Services or People's Legal Aid. Tenants very consistently get better outcomes for having legal representation than not having legal representation. And as we'll be discussing a bit later, Jeff takes a broad number of cases himself. My organization is, in fact, right now expanding some of the services we give. We'll go into detail about that more later. But in the meantime, first step would be calling either of our organizations and seeing if they qualify for one of our services. The next step would also be that the tenant should start gathering their documentation. If they are claiming that they have a defense, that whatever the landlord is claiming in the eviction notice is just not true, then, well, they need to prove that. They need to actually offer up. Now, in theory, it is the landlord's burden to prove grounds to evict, but the reality winds up being that usually it is the burden on the tenant to show some reason why they should not be evicted. So, for example, if the claim is related to non-payment, the best possible defense for that is to be able to immediately gather some proof of payment, a bank transfer, a money order stub, a certified mail stub from having mailed that, names of people who were with the tenant when they went to go pay the money. Another good option would be is if it's a non-payment matter and it's about a claim of an ongoing issue of non-payment, money has not been paid for some time, whether in rent or other fees that are accruing, it might be useful to have the client put together something of just a ledger themselves. Now, that's obviously not necessarily easy. Many of us, well-educated grown adults don't necessarily know how to put together a ledger, but at least trying to get the person to outline, okay, the landlord demanded this much money from me at this date, I paid it on this date. This much money demanded me on this date, I paid at this date. And just
Great.
breaking down those numbers can be a big help.
Great, I think that's really great advice. Thank you, Marcus. And we're going to have the link to both Utah Legal Services and People's Legal Aid on the event webpage. So after you're done with this presentation, you can look on the event site and you should see a link for both PLA, Utah Legal Services, and the Court Self-Help Resources. Well, let's switch gears and hand it over to Jeff, the other Nathaniel, for this presentation. Jeff's going to talk to us about defenses and sort of what happens next with the order of eviction and the consequences of eviction. Jeff?
Great, thanks, Nathaniel. Just to tie off real quick on what Marcus has said there at the end, a lot of that preparation that a social worker or someone that comes into contact with someone that's going through the process of eviction, those things will end up being used as defenses in the eviction proceedings. So anything that we can get documented is likely to be used to benefit the tenant as we go through the process. So if there's been some sort of agreement and it's in writing, we're going to need that to be able to present it to the other side. I've been allotted a few minutes to talk about the defenses, and I think I could sum that up in about 30 seconds. There aren't many. The laws in Utah are pretty heavy-handed against tenants. And for example, the majority of cases that are filed against people for not having paid their rent. So Really, with the exception of someone who's paid their rent and maybe kept a receipt of bank deposit or received a cash receipt from the landlord, there aren't a lot of defenses to not having paid your rent. That being said, the landlords are required to strictly comply with the unlawful detainer statute, which is the statute that allows them to evict someone. Just to sort of drive that point home today, the law changed in May that the law now requires that a landlord provide a 3 business day notice to someone who hasn't paid their rent. I was in court this morning, and the landlord on their own had only provided a 3 calendar day notice. That's a very small distinction in an overall case, but the current case law holds that because the measures and results of an eviction action are so harsh against the tenant, that the landlord has to comply strictly with the law. So we were able to get the case dismissed. That doesn't happen every time, but there are defenses, and one of the reasons why you should definitely seek assistance from either the state courts or Utah Legal Services or People's Legal Aid when you're facing an eviction case or an eviction action. There are just things that a layperson that doesn't practice in this area every day would probably not recognize. So strict compliance with the law is currently our best defense against sort of the mom and pop landlords that attempt to do this on their own.
Jeff, can I actually ask you a question about that comes to mind?
Sure.
So maybe some people heard before that there was a moratorium by the governor on evictions. Hopefully most people know that that has ended, but there has been a federal moratorium. Putting you on the spot, but can you just give a few plain language bullet points about that would be helpful for the audience of people who are trying to help people facing eviction?
Absolutely. So the governor's moratorium for the state of Utah went into effect in March, right at the end of March, and lasted through, I believe it was May 15th. Marcus, you can shake your head no if that was incorrect. So really, there haven't been any resulting cases from that now. Most of those have already been settled or renegotiated. But the CARES Act, and specifically Section 4024 of the CARES Act, provided the federal eviction moratorium that ended July 25th. While that protection has ended, there are certain provisions that require landlords to now provide, well, in my view, it requires landlords to provide a 30-day notice prior to initiating an eviction action. I understand there's some contention about that. And if you're interested, you're welcome to come to court tomorrow and see how it works out. But there are protections that still exist for tenants. For example, landlords aren't supposed to be able to charge late fees for that period of time during the federal eviction moratorium. In addition to that, they aren't supposed to charge the tenants for any other fees that might be associated at the state court level. So our arguments are that they shouldn't be able to charge treble damages or 3 times the daily rent during that period of time. So
and
there,
Jeff, if I may hop in real quick, will you also talk about the scope of the coverage of the CARES Act? What properties these limitations and restrictions and protections, what properties they reach and don't reach?
Absolutely. So the federal law currently does not protect every single property. There are requirements that the rented property has to be what's called a covered property. And that requires, a property can be a covered property in a number of ways. The most common is that they have received some sort of federal tax credit or federal funding for their mortgage, or they have received some other break associated with the CARES Act. Unfortunately, there are a lot of landlords that just flat out own their properties and haven't taken any sort of low income taxpayer credits. So there are a significant number of properties that don't qualify, but it's always worthwhile to see if the property is going to qualify because, as I mentioned before, there aren't a lot of defenses. So with this being one of them, we run it to ground on every case. And I think that should be a starting point for anyone in this area to just verify that the properties either are or aren't covered. And there are a couple ways to do it. There are some searches that you can do online, but one of the most effective ways is to just ask the landlords at the occupancy hearing if they have an FHA loan, if they have received some sort of tax credit, because that will be good evidence and allow us to present a better defense to get either the case dismissed or it pushed back, which equates to more days in the property for the tenant.
Can you talk a little bit more about what happens at those occupancy hearings, what someone can expect if they're facing an occupancy hearing?
Absolutely. So one of the things that all our clients worry about at the occupancy hearing is being able to prove the amounts of money that are owed. And as Marcus so aptly described, the process sort of happens in 3 phases. The first phase is the eviction notice. The second phase is going through who gets to have the right to be in the property. And the third phase is money. So the occupancy hearing is just going to be about who gets the right to be in the property. So it's important to know that while a discussion of money may happen, especially if there's an allegation that some amount of rent has been paid or there was a payment made after the eviction notice, that sort of thing is definitely ripe for inquiry, but really the judge is just going to want to know if the landlord received a payment during the 3 business day period after the notice for eviction was given, or if there was an additional agreement made. If that didn't happen, it's likely that the court is going to grant the order of restitution, which if you just break down those words, that the court is ordering that the tenant restore the property back to the landlord. And it can be as short as 1 day or the same day. Most likely it'll be 3 to 7 days, depending on your specific circumstances. The courts right now have been pretty lenient on extending that time, but when I say extending that time, I mean like maybe they'll get a week instead of the 3 days. That's been our experience in court. I would imagine that Utah Legal Services has had similar success in requesting that extension of time.
Yes, and one thing I think that is worth noting, and I had meant to flag up earlier amid all my other droning on, was that a lot of times when you're working with clients, a big thing that you're going to hear them expressing a lot of fear about is, well, I don't want an eviction on my record. And quite naturally, most individuals you speak with who are on the receiving end of this sort of situation think that means, to the extent they understand that there's this judicial process, that's when the judge signs the eviction order, that is when there's an eviction on your record. It's very important to clarify that actually the damage to a person's credit history, the renter's credit history, happens not at the signing of an eviction order, but at the entering of an eviction lawsuit with the court at all. It happens at the moment of filing the eviction lawsuit. And the reason why is because renters credit reporting companies simply report on whether or not there is a public record that a person was named in an eviction lawsuit. And while the credit reporting companies, disclaim very heavily on their website, well, that, we are only reporting about this, and what we are reporting should not be taken as an inference of blah, 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 blah. But the reality is that most landlords who pull a credit report that shows, well, this person was once named in an eviction lawsuit, they then use that to make an inference, well, this person is not creditworthy or otherwise is not a good tenant, I'm not going to rent to them. The only way to cure that is actually by having the court record sealed, which we can discuss more later. But the point being that to an extent, you're working with anybody who is worried about an eviction on their record, then what they need to be focused first and foremost is avoiding the lawsuit at all costs, to the extent that it is possible.
So I think that's actually a nice segue, Marcus, into talking about what your agency does, how your agency can help, how people request help, who you help, all those things, and sort of why they would want you to represent them versus going it alone. Can you talk about that?
Absolutely. So I alluded to this earlier in my remarks, and I think it's worth reiterating for particularly for service providers out there that it has been statistically shown, and I think actually Mr. Player might even be able to talk about these numbers better than I can, but it has been statistically shown that tenants almost always, or at least a much larger percentage of the time, get better outcomes when they are represented by an attorney than when they are not represented by an attorney, even if they have no defenses whatsoever. And as we've already discussed amid all this, the nature of a defense can be much more of a tricky, ticky-tacky thing to sort out than what might just be obvious from looking at the papers. So that's where we come in. We specialize in this area. We, my office and Jeff's office as well, we specialize in trying to find any manner of defense that can be mounted to an eviction lawsuit. And I'll disclose that for many years, my office's limitation was often we would only actually participate in representing somebody, including negotiating with the landlord, if we thought the case otherwise had a meritorious defense on which we could win if it came to actually arguing in front of the judge at the occupancy hearing. Utah Legal Services has just recently, based on a very generous grant from the Utah Bar Foundation, been able to expand our services and beef up our staffing a little bit more, such that we are now taking cases, even for which there is no defense to be had, to help people try to avoid an eviction or at least get the least painful possible settlement agreement for their departure. Now, then comes the question of, well, who qualifies for our services? Unfortunately, we can't provide legal representation to just anybody who calls us. The two main limitations that we function under are, one, we can only provide representation or even give advice only to United States citizens or legal permanent residents. We make occasional exceptions for different types of cases, certain kinds of wage exploitation cases that arise out of migrant farm worker visas, but otherwise, Utah Legal Services across all our departments can only take cases from citizens or legal permanent residents. The other major limitation we function under is an income and assets limit. If a particular client who's called into us and wants our help makes too much money every month, or has some huge amount of money sitting in the bank, or owns a house, or otherwise has a certain amount in assets more than we can represent, then we cannot represent them. It should be noted, specifically within this crisis time we have, that the way we calculate money does factor in recent job losses. So even if an individual, yourself or anybody you interact with, knows that or believes that they might not qualify for us because before they were fired recently, they were making six figures or whatever, might still be worth having them call us, because with factoring that into our equation for who we can help, they might now qualify. Nathaniel, did I cover all the major beats? Is there anything you think I'm missing here?
Yeah, well, you talked about getting a record sealed. Is that something that ULS can make happen?
Yes. So crucially, as far as record sealing goes, as I was mentioning earlier, if a person is on the receiving end of an eviction lawsuit, crucially, even actually if it's one of those rare instances where the tenant manages to win the eviction lawsuit or reaches some sort of settlement and is able to remain in the property, the fact that that lawsuit entered means that there's now a blemish on that person's credit report. We at least will give advice about sealing on cases where we did not participate in the occupancy hearing and the actual lawsuit itself. We will at least give people advice on how to seal their records, and for cases in which we actually actively participated and were able to either get the case dismissed or reach a favorable settlement, and that settlement was completed, then we just will petition to the court ourselves on behalf of our client to have the records sealed. If it is just one of those advice only matters, we didn't handle the lawsuit and they're just calling us to ask about the sealing, we'll do a consultation to make sure that they are actually eligible in order to be able to have the records sealed. And then we have court ready-made forms that basically just require filling out some personal information, checking a few boxes, and filing them with the court. And they're able to seal on their own.
And Marcus, if I'm helping somebody who doesn't speak English, can ULS still help them?
We absolutely can, yes. We have many Spanish-speaking staff on ULS staff. I am nominally fluent in Spanish, but we have plenty other of actually quite fluent Spanish speakers on our staff. And we also avail ourselves of a interpreter service that allows us to be able to work with any clients who do not speak English or Spanish.
Great. Thank you, Marcus. Jeff, do you want to tell us about People's Legal Aid and how they can help them, who you help?
Absolutely. So we are an entity that just provides eviction defense or defense to a debt collection lawsuit. And primarily what's important to this conference is our eviction aspect. So we don't have some of the similar restrictions that Utah Legal Services does, which is why I think, one, we're a great partnership because we pass referrals back and forth all the time. And it also allows us to sort of gap fill where Utah Legal Services has been in existence for a very long time here in Utah. We're able to catch those folks that they're unable to help, whether it's based on their asset level or their citizenship in the country. So we also sort of actively mine for cases through the court's databases. Because we don't charge fees, we're able to do sort of in-person solicitations. So we try our best to go through court calendars, identify cases that we can assist on, and then we sort of cold call people and offer our services. And most of the time, what we do is convince people that it really doesn't cost any money. So we can take cases from the very beginning all the way through the end.
Jeff, can I just ask, what does the cold call sound like? Like if I were a social worker and somebody said, oh, there was some weird group who called me and said they could represent me, my mind might go, uh-oh, that sounds like a scam. That sounds sketchy. So tell me what that sounds like. And so people can know that that's actually not sketchy and that's helpful.
Well, and Jeff, you do always start off the call with talking about trying to help them extend their car's warranty, correct?
Right, exactly. And ask for their social security number. So basically how it goes is we just say, we scanned the court calendar and we recognize that you have a hearing for an eviction lawsuit coming up this Thursday. We're a nonprofit and we'd like to offer you either representation if you'd like to go use our services, or we can give you some advice based on your case if you'd like to go it alone. Most of the time, the folks are more than excited to have us just take their case for them. A lot of our clients, we sign up either the day before or 2 days before their hearings. So everything is done in a very quick fashion, but we've done literally hundreds of these cases, and unfortunately the vast majority of them are very similar. So all of our attorneys and our intake folks are pretty well versed in identifying the issues and getting it out in front of that before the hearing. So it doesn't sound quite as shaky as cold calls from telemarketers, but I do understand we're probably the only organization that cold calls and offers free legal representation. So I can see how that would be a little questionable, but once we get people to believe, they are on board with the process. So what we do in the nutshell is try to negotiate on our client's behalf or identify the defenses. So we also take all cases, whether they have a defense or not. Every case has the possibility of a settlement. So that's where we try to save them thousands of dollars by not defaulting or failing to appear in court, which can be just extremely costly for the tenant. So we tell people we're like a Band-Aid on a sort of a gushing wound, but we are also tied in with resources like Utah Legal Services, Utah Community Action, Utah Housing Coalition, 5 counties, anyone that's received CARES Act money. Part of what we'll try to do is get them in touch with the right resource to be able to provide them either a new place to be housed or some funds to get caught up on the rent.
One quick thing I just want to flag up, because I know we're coming towards the end of our time. I just saw an alert from the news that apparently there has been an announcement that there is an expectation of some manner of there was some news press coverage in a couple weeks ago, I think first week of August, about an executive order relating to evictions. It in itself did not by itself do anything, but I did just see an announcement that apparently something is going to be announced later this evening. So when this broadcast is being viewed, we will not have had the chance to review it and opine on the scope and effect of that announcement. Hopefully that is something that we'll be able to be gap filled in tomorrow.
I'll do my best when it's live. I want to ask you both a question. If I am a social worker and I'm helping my own client, and we've had a relationship long before they were dealing with the eviction process, how can I interface with your organization? How can I help you? Would you share information with me if I'm helping this person? Or how does that work? How do we collaborate effectively if I'm a social worker?
First of all, I'll say that at least for our part for Utah Legal Services, we are always very appreciative to be able to work with caseworkers, social workers, etc., whenever possible, particularly for the particularly vulnerable populations we work for. We are always thrilled to have you in the mix. In order to be able to do that, we just have to observe some formalities with respect to our ethical obligations under attorney ethics rules. We are technically not even allowed to acknowledge to you that a given tenant is in fact our client unless that client has given the go-ahead. However, we will accept simple verbal confirmation. We generally prefer to receive something by way of an email from the client saying, I give you permission to talk to person in this regard about all aspects of my case, but with any sort of verification directly from a client that we can talk to a third party about their case, we will readily do so. I know some other offices require release of information. We have our own in-house release that we will disseminate to our clients, but otherwise, any confirmation from our client will do.
And we're in a very similar boat. It's usually easier to enter into a negotiation if the landlord knows that there is someone else that's like actively assisting them to either find funds or find a new place to go. One of the things that we really depend on social workers for and mediators that get involved is to be able to identify the funds that they might be eligible for, and also if they can assist us in finding another place for the tenant to move to, then it's much easier to enter into a stipulated negotiation with the landlord if we have like an idea of when they can move out. So we love working with them and have a pretty good relationship with those that I think of, at least from my perspective, have a good relationship with them.
Great. Just to recap what we've talked about, we covered the eviction process. We talked about notices. Often it's a 3-day notice. We talked about the 3-day summons. We talked about filing an answer, the importance of that. We've talked about the occupancy hearing, the defenses, and some of the consequences of eviction. I guess my last question to you both is like, what is the one thing that we haven't talked about that you want people to know about on this call? Marcus, I'll let you go first.
I think if I had to reduce it to one thing, it's try to encourage anyone you're working with to provide as much documentation, piece of paper as possible. Ultimately, a landlord-tenant relationship is under the law treated as fundamentally a contractual relationship. While a binding oral contracts can exist, the reality is that most of the relationship is usually dictated by some pieces of paper somewhere: the lease, the notice, the court papers, etc., any proofs of payments. You know, these aren't pieces of paper, but witnesses who could testify on behalf of a tenant. But for the most part, it's pieces of paper, and the sooner you can have somebody gathering together those pieces of paper for somebody like one of us to be able to look at, the better.
Great, that's good advice. And Jeff?
What I would encourage is for people to try to find a resource either before or right after you get the eviction notice, because it's easier to have someone help you make a decision on whether or not you're going to stay in the apartment, whether you're going to pay, whether you're going to try to fight it in court, because there are all sorts of costs that will accrue as soon as the lawsuit is initiated. And for example, you may, we had a client who was just short $400 on rent, wasn't able to make it up. The eviction process started, and then once you add 3 times the daily rent, which has been the, that's what is called treble damages, 3 times the daily rent and some fees, add the attorney's fees, the court costs, that $400 delinquency on your rent can very easily get into the thousands of dollars. So while it's super important, and I totally back Marcus on his recommendation to start, accumulating the documents to defend yourself, it's just beneficial to reach out and get a consultation on, like, what should I do? Should I move out? Should I pay the $400? Should I try to fight this? Because likely we can figure out a way to avert like a huge debt collection action that is going to be difficult in the future to fight.
Great. I think those are great pieces of advice, both of them. Thank you both, Marcus and Jeff, for sharing your expertise. I think that will be the end of the pre-recorded section, and then I will be around and answer questions live when this is done playing. Thanks again to Marcus and Jeff for being a part of this. Thank you very much.
Thank you, Nathaniel. Thank you to Utah Housing Coalition, and thank you everyone who watched. We really appreciate it.